Right, so common questions clients have. Let's go over some of the questions I get. I do a lot of webinars on COVID, probably 1 or 2 a week. Should we go back over all our denial decisions since March? Well, the law is retroactive to March 9, in light of the Essential Employees Law. Do you understand the question? So you've made decisions, perhaps, between March and now, October, on either accepting or denying cases. This law did not get passed until September. Should you now go back over and decide, did you make the right decision on all these other cases? Now, there's 3 benefits in comp, right? Lost wages, medical, and then the one I'm dealing with mostly, which is permanency in court. My feeling is if you haven't heard anything in months from people that you've made decisions on, and they haven't brought claims with lawyers, don't reopen the cases. There's no real issue at this point. They probably got paid somehow. Their bills have been taken care of, and they may not have hired a lawyer. Most people have not sued in court. Most people want their lost time benefits, and they may or may not even have any medical bills because a lot of people treat at home, okay? And now it's been months and you haven't heard from them. I would not go back over your cases. If somebody goes to court and tries to contest a case, then your lawyer will deal with that, okay? But I think you're making unnecessary work for yourself. All right, can we settle with claimants directly if they don't have formal claim petitions? So let's say Danielle had a COVID claim and she had a rough time of it, but she's back to work at Fairview. And now, we want to make sure that Danielle doesn't bring a claim petition in court. Can we call her up and say, hey, Danielle, how about if we send you a check for $5,000 and then you cash that check and sign an agreement saying you cannot file any claim petition in the Division of Workers' Compensation? Sounds good, but no, we cannot do that. And why? Because in New Jersey, all workers' compensation cases must go through a judge to be settled. There is no such thing as a settlement outside of workers' comp court in our state. There is no such thing. So unfortunately, if you want to settle a case, that person needs a lawyer and needs to file a claim petition, and it must be done in comp court. Now, last question on this slide. Will we be able to Section 20 compensable cases where we argue there is no proof of impairment? Okay, this is a tricky question. So let me just go back to Danielle again. Danielle, let's assume that you had COVID and we know you're essential and you definitely got it from work, okay? But Fairview's position is you really don't have any impairment. So you're in court, you got a lawyer, and we got Fairview's lawyer saying, we're not contesting she has COVID and she had it. We're contesting that she has anything permanently wrong with her. Can we Section 20 that case? First of all, what is a Section 20? A Section 20 is a way to close the case out forever. She can never come back. She can never reopen it. Most cases are not Section 20. Most cases, a person gets a percentage of disability, 20% of the shoulder, 40% of the back, and then they can reopen the case every 2 years. That's not popular with most of my clients, whether it's Verizon or whether it's Teaneck Township or whether it's, Rahway or whoever my client is. That's not popular. They like to close them out in a Section 20. So do we. Okay, we can do that if Danielle and her attorney are agreeable and the judge will approve it. We can Section 20 the case, lump sum check. She takes it, she goes away. She can never come back. So that is the best way to settle these cases. Okay. All right, let's go to some more questions. What role will medical monitoring play? Let me just tell you what medical monitoring is, first of all. There are very few cases where this happens, but it has happened. When I was, starting out at Capehart, most cases we had were asbestos cases. There were so many asbestos cases compared to all the other cases that was mostly what we did, okay? Now, with asbestos cases, it could be like COVID. With asbestos, if you are being exposed to a high volume of asbestos, you might find on x-ray changes in your lung. The exterior of your lung might be burned, there might be some plaques, and yet your breathing could be totally normal, absolutely normal. So what happens? How would we settle those cases? Well, what we did is we would say, okay, your breathing's fine, you don't have no impairment, we're not going to give you any money. But what we will do is we'll do an annual x-ray. So when we were working for DuPont or ExxonMobil, we didn't want to pay money because there was no impairment, but we knew something was wrong with the lungs, and that might have been caused by asbestos, or probably was caused by asbestos. And we would every year do an exam with a pulmonologist. Now, why is that important? You all heard the statute of limitations. In workers' comp court, if more than 2 years runs from the last payment of medical or temp or permanency, the case is closed for good. But if we send an employee to a pulmonologist who does testing on 1 day a year, that adds 2 years to your claim. You can reopen the case up to 2 years later. So the claimants like medical monitoring because what they were worried about is, how do I know that 15 years from now I won't get asbestosis? Asbestosis is different than having scarring on the outside of your lung. It's when the interior of your lungs becomes scarred and you can't even breathe, okay? And unfortunately, you're going to die from asbestosis. So the employee said, I don't want the money. What I want is to make sure that me and my family are protected. And that's why we would do medical monitoring. Now, how does that pertain to COVID? Well, for all of us, we've all read about COVID. We're all worried about it. We're all wearing masks. One of the reasons we're all worried about it is nobody can tell us what this is going to do to us in 5 years or 10 years, okay? Fortunately, no one in my family has it, but I have a good friend who's a doctor who got it, and he told me his major concern is not now, he's back to work. He works in Hoboken, he works in Clifton, he works pretty much in 3 or 4 counties in North Jersey, but he is worried about what's going to happen in 10 years, and he's a doctor. Who knows? Nobody knows, because coronavirus hasn't been studied long enough. There are lots of coronaviruses. This is coronavirus 19. And the essential employees law is only about coronavirus 19, not anything else. But until it's studied by scientists, we don't know what damage this virus could do. You could be totally normal. Here's something that's possible. You could be totally normal right now, and 10 years from now, you could have a real serious problem with your lungs. So I do think, projecting, I do think lawyers are going to come to us and say, look, my client has scarring or marks on her lungs, and that's not normal, and it wasn't there before. Of course, we're going to have to get all of her prior records to see if it's true. And all I want is for you to monitor my client's lungs once a year. And then that's up to my client, okay? So I have the largest comp practice in New Jersey, and I have all different kinds of clients. Not just public sector, I have private sector, big clients, Amazon among them. And they have to make the decision whether they're going to do that or not. All right, now what about large hospital bills paid under healthcare or Medicare? That's a big issue for us, because if you were in a hospital a long time and let's say you put the bills through Medicare, and you had a Medicare card, and then Medicare finds out you have a workers' comp claim, they're going to want their money back. So there's a Medicare Secondary Payer Act that many of you may not be aware of. But the theory is Medicare wants to be the secondary payer if there's a primary payer, and a primary payer might be workers' comp. So Medicare gets involved in our cases. They'll literally send us letters saying, we know that Jim Smith has a workers' comp claim, and we paid $100,000 to Hackensack Hospital, okay? And it was for his COVID, and now he's got a comp claim. And if he's going to recover in this comp case, we want our money back. So yes, that's a big problem for us. We have to deal with that. We can't just say, well, you know, good luck, Medicare, we're going to settle this case without getting you involved. We cannot do that. We have to deal with them. Now, question from Mike, what liability will the company public entity have if the monitoring determines that the patient, and the rest of it I couldn't read, probably has, you know, COVID-19 or some kind of an impairment? Well, if it's a workers' compensation case, okay, lungs are deteriorating over time. If it's a workers' compensation case, Mike, good question. And let's say 10 years from now, we've been monitoring this employee once a year. And then 10 years from now, suddenly things take a turn for the worse. Every year that employee has been going for a chest x-ray, not terribly expensive, by the way. And all of a sudden on the 10th year, that chest x-ray is really abnormal. And now the doctor says, we're going to send Aisha to a pulmonologist for spirometry. And we want to see how she's breathing. And now her breathing's terrible. And now she has a 50% forced expiratory volume. That means she can't expire air. She can't breathe out air the way she used to. She's only half of what she used to. Or she can't inspire air, forced vital capacity the way she used to. What's going to happen, Mike, is we're going to get a claim petition at that point. The lawyer will come back in and reactivate the comp claim and say, I want compensation for that 50% decrement. And we would go to a rate chart. And if the judge feels that there's a 50% disability, I'm just going to show you what happens in a case like that. The judge will look to our schedule of benefits and say, well, 50% is $184,000. And we would then probably be ordered at the end of the trial to pay Aisha $184,000 because that would be the disability objectively proven by the spirometry, that's the breathing test, that she has, okay? So the importance of medical monitoring, Mike, is that the case doesn't close, like most cases. It really doesn't close. It stays alive because every year you add 2 more years. Good question. Okay, how important are medical experts? Well, as you can tell from everything I've been saying, medical experts are crucial. Medical experts have to be highly qualified, and they have the same problem we all have, by the way. How much do they know about COVID-19? You know, where are their resources? What are they reading? Well, hopefully they're reading all the literature that's coming out that we are trying to read. And hopefully they are very experienced in evaluating impairment. So who do I hire? Most of the cases I have are alleging pulmonary problems. Some of them are alleging cardiac problems. If it's pulmonary and cardiac, I'm hiring an internist. If it's just pulmonary, I'm probably hiring a board certified pulmonologist. If it's just cardiac, I'm hiring a cardiologist, okay? A few cases have alleged psychiatric. Why? Why would there be a claim for psychiatric? Well, because some people are saying, I'm fine right now, except for one thing. I'm worried sick about my future, okay? Now, we can't, I'm a defense attorney, okay? So I represent hundreds of school boards and I represent hundreds of towns. My job is to engage in due diligence. I'm not going to accept a blanket statement that this employee should be compensated for being anxious without first doing my discovery. How long have you had that problem? Do you have anxiety? Are you taking medications? Have you been taking them for a long time? I want to get all those records and then we'll deal with the case. But I need a psychiatrist who is going to do an evaluation that is useful in workers' comp and knows workers' comp. There is a very good psychiatrist in Wyckoff that I have been using for years, and his name is David Galena, and he does a great job. So that's probably who I would hire.